This is Richard Jacobs with myduiattorney.org, and I'm here today with Stephen Tinsley, a DUI defense lawyer out of Florida, specifically in the Orlando area. How you doing, Mr. Tinsley?
Very good, sir. How are you?
Good. Thanks for taking the time today to do the interview. I appreciate it very much. Without any further ado, let me get into the questions. My first question for you is, what makes you choose to handle DUI cases, and why do you practice this area of law?
I do criminal defense, and DUI is a major area of criminal defense. It does have the added benefit of being winnable. In some jurisdictions, a DUI is like a death knell. The judges expect you to plead, the state expects you to plead, and for the people who don't plead, there are very severe consequences. Orange, Osceola counties are places in Florida where DUIs can be won and are won on a regular basis. And the judges, frankly, don't punish you for losing. In some jurisdictions, in fact, you walk away from a losing case feeling like you've been punished for merely asking for a trial.
Huh, okay. So how many DUI cases have you handled, and in what time period?
I've been in private practice since 1987, and I don't count them. I know I'm well over 500 DUI cases.
Wow, okay. That's quite a bit. So what is unique? You've already started speaking about this, but what else is unique about the DUI laws in the counties you serve and in the state of Florida as well?
Well, in Osceola County at this point in time, and in Orange County at this point in time, and a few other counties in Florida, the courts have ruled that the breath test results are not admissible in evidence. So that a person who's stopped for DUI, who takes a breath test and gets whatever score they're going to get, the attorney for that person will file a motion. It's called a motion in limine, and the courts will enter an order that tells the state attorney's office that during the course of the trial they are forbidden to make any kind of references to breath test results. All right, so it's a very big deal. For that reason, the state attorney for the Ninth Judicial Circuit, which is Orange and Osceola County, has instituted a DUI diversion program. So for first-time DUI offenders with no car accidents, with no prior driving criminal charges, who didn't have children in the car, they will be offered a diversion, which, well, it takes 14 months. It's pretty expensive and involves virtually everything a person on probation would do.
Okay.
When it's done, the DUI charges are dropped. And that was virtually unheard of up until the courts started throwing out these breath test results.
Okay. Yeah, that's very unique. What's the consequence of that? Are arresting officers going more towards blood tests, or what else are you seeing that's a result of this change?
Well, I mean, in Florida, law enforcement officers can't draw blood unless there's been an accident that's involved death or serious bodily injury. There are some other very, very minor exceptions, but that's the primary basis on which blood is drawn. When a police officer makes a stop for a DUI, they do the normal investigation, which involves the field sobriety exercises, field sobriety tests, the questions that they try to encourage the driver to answer, and after the arrest, they demand a breath test. The breath test is taken. And it gets circumvented in Orange and Osceola County. Now, every DUI has two components. Person's arrested for DUI, and they're charged with the criminal charge of state of Florida versus that person for DUI. At the same time, in the vast majority of cases, there's a civil administrative suspension of the driving privilege, which takes effect the night the person's arrested.
Okay.
All right. There's a person charged with DUI in Florida has two cases pending against them, not one.
Okay, I understand.
Okay.
Gotcha.
Well, it's the breath test results will still be admissible at the civil hearing. So there are consequences for taking a breath test. However, in the criminal case, it's greatly improved. Now, in Florida, a person who takes a breath test, who's a person arrested for DUI, who takes a breath test, goes to trial and wins the trial. Not only wins the trial, but as a result of winning the trial, the civil administrative driver's license suspension for unlawful breath alcohol level is then retroactively removed from their driving record.
Wow. Huh.
So you take so in Orange and Osceola County right now, regardless of what you think about the quality of the breath, the accuracy of the machine, you take the breath test. All right. You go to trial. You win the trial. The driver's license suspension will come off your record retroactively. Now, the situation changes when the courts reverse this position and make the breath test admissible in court. And
Right.
and people, when they go out for dinner or do whatever they're doing that involves consuming alcohol outside their home, are probably not going to be consulting local legal standards to determine whether or not their breath test results are going to be admissible if they get a DUI later that evening. Absolutely, the very best way to avoid the whole problem is not to drive a motor vehicle after consuming alcohol.
Okay, well, this is it's still very, very helpful to know. All right. Is there a typical circumstance of the people that you represent? Do you see more first-time offenders or more men or women? Are there any commonalities?
DUIs tend to have a relatively predictable sequence of events. Now, these are DUIs that don't involve collisions. All right.
Okay.
They almost invariably start off with a police officer who has some kind of problem about the way someone's driving. They may be going too fast, which indicates impairment, or they may be going too slow, and they'll say that indicates impairment. Delay beyond, or the lights may be off in an area that's well lit, and they'll say that alcohol is affecting their vision, and therefore they have a problem with that. They may not like the way the car stops. Maybe they stop too far past the stop bar. Maybe they stop too soon, too far. Maybe they're moving inside their lane. Maybe they're moving outside their lane. There's going to be a complaint about the driving. Police officer acts blue lights, and the driver pulls over. Police officer is going to usually have some kind of problem with the way the person pulled over. Pulled over too soon, pulled over too late, didn't like where they pulled over, didn't like the way they pulled over. There'll be something in their report that says that the way they pulled over indicates possible impairment. They walk up to the car, ask for license and registration. They're going to put in the report that the person appeared to be confused and slow in his motions, and that when they finally gave him the driver's license and registration, they also gave him like a Barney's coffee card. The officer is going to say they went back to their car, they ran this information, came back to the car, where they, for the second time, could smell the moderate or strong odor of alcoholic beverages coming from the breath of the person driving, and they're going to ask them to step out of the car to do some field sobriety exercises. The police report's going to say the police officer didn't like the way the person got out of the car. They got out of the car, they were ungraceful, they leaned against the car for support. Doesn't matter whether this is a pickup truck that's set 2 feet off the ground. If the person gets out of the car and has their car on the doorknob, they're going to say they're holding onto the car because they're that impaired. They step out. The police report's going to say the person stepped out of the car, and if the person's leaning against the car, they are of course leaning against the car because they're so impaired. They ask them to do field sobriety exercises, which they uniformly fail to pass, and the person is placed under arrest. The person is then is asked a variety of questions, usually before the field sobriety exercises, about where they've been, where they're going, how much they drank, when they ate, how much they ate. They're going to be asked about their medications. And when the arrest is made, then the person is going to be told that if you don't take a breath test, your license will be suspended for between 6 months and a year and a half. In Osceola County, the sheriff vehicles have breath testing equipment inside the specially dedicated DUI vehicles. Okay. They also have printing equipment. They have videos inside the police cars. They have videos outside the police cars, digital recording devices on the police officers themselves. And if you watch the video, you'll frequently see the police officer have their hand resting on some kind of device on their belt, which is the device which allows them to turn the recording on and off as they basically arrange for the screenplay that's going to be recorded on their motor vehicle and presented to a jury for its later consumption. That happens in at least 65% of the DUIs I see. Some variation of the facts I've just recited.
It sounds like you're, first of all, very, very, very familiar with what goes on, and second, I'm betting you're clients are shaking their heads and saying, "How did you know? How did you know?" When you tell them that.
Well, to be honest with you, when I meet a new client, as soon as I determine that this is not a case involving a collision, I tell them what I expect the police report to say before I read the police report. And and after you've seen the first 500 or 600 of these, it doesn't take a rocket scientist to realize that there's a pattern here. In Orange and Osceola County, the sheriff's office uses a DUI form, which is literally fill in the blank. It types out that the person's breath, the officer could smell the blank odor of alcoholic beverages coming from the person, and officers encouraged to write in moderate, strong, or sometimes slight. It happens. The officer is going to say that when the person's back in the back of the police car, the officer went about doing duties outside the motor vehicle. And then when he got back into the car, that the interior of his car is now reeking of the smell of alcoholic beverage, which has been coming off the person who's been locked in the backseat of the car all this time. The newer vehicles have got very high quality in-car videos. So when the person's put back in the backseat of the car, they are being recorded, video and audio. So you got some people back there who are literally praying. You got some people who are calling their girlfriend, asking for help, and a variety of other scenarios. One of the most amazing cases I had was a person whose natural response to police officers was, bad on a good day. He's in the back of a police car and questioning the police officer's sexual preference and just being as big a horse's ass as he possibly can. It never occurred to him that a modern police car might be able to record all this, so it could be shown later on to a jury, possibly with popcorn. A person under arrest needs to be on their best behavior. Treat the police officer with respect. He'll probably treat you with respect. Now, keep in mind, the police officer is going down a checklist. One of the reoccurring matters in DUIs is that police officers they want you to talk. Everything you say is being recorded. Virtually any kind of explanation you give is going to be recorded as some kind of indication of exactly how impaired you are by alcohol. There's almost no innocent event that isn't going to be somehow related to your consumption of alcohol. If you say you had 2, you have to imagine the police officer and the jury hearing 6. And the phrase "a couple" should only be used by people who have a death wish that we haven't discussed. It's just that. I mean, there are alcoholics who think that the phrase "a couple" excuses having half a dozen drinks.
Right.
And it's stereotypical. And there are a lot of people out there who have drinking issues in their family. And when these people get on juries and they hear someone say they just had a couple, I just can't imagine any worse language they could use, especially if they've only had 2.
Okay.
It's not illegal to drive a car after consuming alcohol in the state of Florida. It's only illegal to drive a car after consuming alcohol if you've done so has put you into a condition where your breath alcohol level is over 0.08 or where your normal faculties are impaired. Okay, so it's a judgment call. Every liquor store, every restaurant, every bar in town has got a parking lot. You can't open up a bar without putting in a parking lot. So the problem with this is the person who's going to be out drinking has got to make a judgment call. And one of the first things that are affected by alcohol is judgment. So, bottom line is that you can have beer with your dinner, a beer or 2 beers, spread it out over time, mix it with food, leave perfectly sober, be totally unaffected, have a breath score well under the legal limit, and yet smell like alcohol. Police officer pulls you over. All he's got to do is imagine that he can smell alcohol, and then the show was on. Step out of the car, want you to do these field sobriety exercises. They have you looking at pens. They're going to give you these field sobriety tests, which are designed to confuse you, designed to mislead you, and which will give the police officer the conclusion that they're looking for.